all the way to the Supreme Court. Well, good luck with that, because the court is going to reject 99% of the petitions for certiorari that are submitted to the court. Petitions for certiorari is a piece of paper. Actually, it's a book. It looks like this, printed this size. And in it, the lawyers for the party who has lost in the lower court attempts to persuade the court to grant the petition of certiorari and review the case and decide it my way instead of the wrong way that the court below decided it. So as I say, there's 8,000 of these petitions for certiorari that are received throughout the year by the Supreme Court, and they cull through those with the substantial assistance of the law clerks who work for the justices, and agree to decide only about 75 of them. The rules of the Supreme Court, they have rules that govern how they do their business procedurally. And Rule 10 of the Supreme Court lays out the considerations governing review on certiorari. And they don't fool around. They tell you right up front that review on writ of certiorari is not a matter of right, but of judicial discretion. They have discretionary jurisdiction. They do not have to decide the cases that are presented to us. They can simply say, petition denied. Nothing is decided. The decision of the lower court stands. The court says in Rule 10 that certiorari will be granted only for compelling reasons, and then it lists some of the reasons that may or may not be considered compelling. One of them is there's a conflict on the same issue of law between the circuits. The Ninth Circuit might decide whether the, let's say the Stolen Valor Act, the liar law, might decide that it's unconstitutional, as it did. And the Tenth Circuit, sitting in Denver, in a different case, might decide that it's constitutional, which it did. Well, there's a conflict in the circuits on the question of whether a particular federal law is constitutional. So that's a compelling reason. The court doesn't take all of the cases where there are conflicts, but that's a reason that would encourage the court to take the case. Then does the lower court case decide an important federal question that departs from a decision of the Supreme Court? Seems to be inconsistent with what we decided before, and it's a federal question. Note that it has to be a federal question. The court does not exist as a court of last resort to correct mistakes made by lower courts. You know, when the California Supreme Court decides the question of state law, that's it. That's the end of the road. Case is over. There is no basis for going to the United States Supreme Court unless there's a federal issue in the case. We'll come back to that notion later on. And the court can also agree to hear, grant certiorari, in cases coming directly from state courts, where the state court has decided a federal question inconsistent with the way the court might have decided it, and so on. And then the court admonishes litigants, whoever reads these rules, that a petition is rarely granted when the asserted error consists of erroneous factual findings or the misapplication of a properly stated rule of law. You're not going to argue about the facts in the Supreme Court. They're there to decide what the law is, not what happened, but what the law is. So that's how you get to the Supreme Court, via a petition for certiorari. And as I say, statistically, the chance of getting your case heard is less than 1%, 75 out of 8,000 or something like that. It takes a vote of 4 justices to grant certiorari. Of course, it takes a vote of 5 to win the case. And sometimes there's some strategy going on where a justice can count heads and see that if the court takes the case, what the justice thinks is the right outcome is going to lose, and therefore he or she might not vote to take the case. Occasionally happens. Once the court has granted certiorari, said, we're going to take the case, then the court hands down, the clerk's office sends out to the lawyers a briefing schedule, and the lawyers then write briefs to the Supreme Court. And briefs are not brief, they're books. Here is a brief in the Supreme Court, printed. And as the briefs are as long as the lawyers can get away with, the current restriction on briefs in the court, I think, is 15,000 words limit. So the party who lost in the lower court files a brief, one of these books. 30 days later, the party who won in the lower court responds to that, files its brief, and then within 10 days or so after that, the petitioner, the party who's asked the court to take the case, can file a reply brief to that. When the briefs are all filed, then the court sets the case down for oral argument in the court a month or so later. And as I said, the court hears argument about 40 days a year. It's the only time that the justices appear in public is for argument and to announce the decision. Typically, overwhelmingly, in the overwhelming number of cases, the oral argument lasts 1 hour per case. Back in the 19th century, they used to go on for days. Now it's 1 hour per case. Each side gets half an hour. There is no television allowed by the court. The audio, they have recorded audio of the arguments from the beginning of recording equipment, and they used to embargo them for 3 years. Couldn't listen to the argument. They gave them to the National Archives, and you couldn't hear what the lawyers said and the questions the justices asked. For 3 years after argument, they gradually whittled that down so that nowadays, at least in a controversial case, the court will provide the audio same day. So you can hear for example, I'm sure that in the Proposition 8 case, when it's argued in a couple of months, that the audio will be available same day, and the transcript of the argument is available on a daily basis. After the justices hear argument in the court, it's the courtroom on the right, they then meet in a weekly conference, just the justices. The Chief Justice sits at one end of the table, and the other justices sit around. Nobody else there, no clerks, no stenographers, no court reporters, nothing. Just the justices, run by the Chief Justice. And they vote on how the cases that they heard argument that week should be decided. There may be a little discussion, but they vote. And then one of the justices is named to write the opinion for the court on the way that the majority voted for the case to come up. If the Chief Justice is in the majority, the Chief Justice decides who writes the majority opinion. Chief Justice Roberts can and does keep opinions that he really cares about for himself. The Chief can write the opinion himself, or he can designate another justice who has voted with the majority to write the opinion. If the Chief Justice is not in the majority, the job of assigning the opinion, the majority opinion, belongs to the most senior justice who did vote for the majority. And then once they decide who's going to write the opinion, they go back to their chambers. They may or may not talk again for months. That's certainly about the case. They communicate by memoranda occasionally, and after a time working on the case, the justice who's writing the opinion, satisfied with the opinion, circulates it to all of the other justices as a draft. And then the other justices either sign on to it, say, I join without reservation. Or, I would join your opinion if you would drop a footnote at this place and make sure that nobody thinks we're deciding some other point that may be related here. I want to qualify it in some way. Or, I will join your opinion if you'll get rid of part 3, which I believe is unnecessary to be decided here, and will cause all sorts of mischief. So if you'll drop that, I'll gladly join your opinion. And the justice who wrote the opinion may or may not do that, gets another vote if he or she does change the opinion. But if the justice says, no, I'm going to stick with what I got, well, then the justice who wanted to change may write a concurring opinion, or may be so serious as to provoke a dissenting opinion. So after the little horse trading that goes on, and the circulation of opinions and drafts and changes and so on, when everybody's finished, satisfied with the majority and the concurring and the dissenting opinions, if there are any, then the decision is filed with the clerk of the court, and it becomes public. And actually, it doesn't get filed until it's announced in court. They show up for court and sit down, and Chief Justice Roberts will say, Justice Scalia will announce the decision of the court in X versus Y. And Scalia summarizes his decision. Occasionally, they'll read parts of their opinion if they feel very strongly about it. Accountability. How can this institution of government be accountable in a democracy? They are not elected by the people. They are just 9 citizens who get to make the law for everybody, and including telling the president and the Congress that they've screwed up and what they've done is unconstitutional. Well, they're accountable in a couple of ways. Their arguments are held not behind closed doors, but in open court, and you can hear the justices. You can go see them. Members of the public, open to the public. Hard to get a seat. You have to stand in line sometimes. But the arguments are open to the public, and you can see the justices struggling with what to do in the case. It's an exciting intellectual exercise to see a Supreme Court argument. Have any of you seen a Supreme Court argument? Next time you're in Washington, I recommend doing it. Go out of your way. The briefs that are filed by the parties are, of course, matters of public record. Anybody can see them, see what the arguments were that were made to the court. And then the opinions that the justices hand down when they decide the case are, of course, public documents. They're open to public scrutiny. Scholars across the country go over them, nitpick them to death, criticize them, and so on. So they're accountable by the quality of their reasoning, if nothing else. Let's look quickly at what the court did last term. As I said, they decided 75 cases. 15 of them were 5-4, squeakers. The vote of one justice made the difference. And it's almost always the highest profile, most contentious cases that are 5-4. Justice Kennedy was in the majority of those 15 cases. He was in the majority 12 times. In other words, his vote made the difference in 12 of the 15 5-4 decisions. Chief Justice Roberts was in the majority in only 9 of those 5-4 decisions. So you can legitimately ask, whose court is this anyway? It seems to go the way Justice Kennedy goes in most cases. The major surprise, of course, was the healthcare decision last June, where Kennedy and Roberts split. Kennedy was a dissenter. Roberts wrote the opinion that upheld the Obamacare law. There have been more than 100 5-4 decisions since Roberts joined the court in 2006. He has sided with the liberals, the so-called political liberals on the court, exactly once in those 100 decisions. That was the healthcare decision. Whereas Kennedy sided with the liberals 25 times. Thomas and Scalia sided with the liberals twice in 100 or so 5-4 decisions. Alito sided with the liberals never. As I said, Kagan voted with Kennedy more than any other member of the court, 83% of the time last year. On the conservative side, it's very cohesive. Scalia and Thomas voted together over 90% of the time. Same with Roberts and Alito. So that's the court that we're dealing with today. And next, we're going to look at the features of the American legal system that affect the meaning of freedom of speech and the press. And we're going to breeze through them on Tuesday. So I'll see that. I'm going to quit a little early most of the time because they're pounding at the doors waiting to get in here, and I want to give you a chance to get where I let you go.
just whip it around that way so we can work in this area. Thank you. Dan, if you want to raise, I have some more announcements. Thank you.